that you're going to be in our prisons for 35 years because you don't know how to behave. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready to get you out of our...
Everyone. With the dismissal of the remaining case.
Tell me which one we're dismissing. That'll be the easier one.
Okay, we're dismissing 353.
353. Got it. Thank you. Good morning, sir. Are you John Jones?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading in each case of the indictment?
Yes, Your Honor.
Right away, you can tell this judge is completely done with this defendant's behavior. And notice something important here. She's not just talking about the original crimes anymore. She's talking about conduct inside the jail itself. In a courtroom, attitude matters more than people realize. Smirking, joking about grabbing a bailiff's weapon, acting disruptive, all of that shapes how the court sees your character. And when a judge openly says, "We know everything you're doing," that's a warning shot. This isn't just about punishment now. It's about whether the system believes you're dangerous even behind.
And obviously, Mr. Coleman, you've taken everything into consideration with regard to the facts, the jail incidents, as well as the wishes of the family and making these offers.
That is correct, Judge. And just for the court's information, there is a member or members of the victim's family here in the present room today.
Okay.
And I've conferred with her about the case.
Okay. Mr. Jones, this is difficult for me because based on your behavior, honestly, I don't want to go along with anything. But it sounds like if Mr. Coleman has discussed this with everyone and understands the underlying facts of the offenses, what has been going on in a jail, I'm going to go along really only because I trust him to the extent that I do. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with, see, and are we going on just, what counts are we going on that?
Which case?
That's the unauthorized use of the vehicles.
Well, it was just the first paragraph. First paragraph should be fine.
So the state jail.
Yes, ma'am. Well, I'm showing only one paragraph.
So it is that. Okay, gotcha. So you're charged in 24 DCC.
This moment is colder than it sounds. Listen carefully. The judge literally says she doesn't want to go along with the deal because of his behavior, but she trusts the prosecutor's judgment enough to proceed anyway. That tells you the plea agreement was probably negotiated heavily behind the scenes. And legally, once a defendant pleads guilty voluntarily like this, they're giving up huge rights, including the right to trial and, in many cases, appeal options too. But emotionally, the atmosphere in this courtroom already feels like everyone expects this guy to...
ER 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with. And then finally, in cause number 25, BCCR 1352, you're charged with the first-degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. I have here on the tablet in all three of those cases documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder.
Here's where things become official. Once the judge confirms he's competent, understands a plea, and admits guilt voluntarily, the legal door basically closes behind him. No dramatic last-minute escape. No trial twists. Just sentencing. And notice how calm he sounds through all of this. No emotion, no panic, barely any reaction while pleading guilty to murder, aggravated robbery, and vehicle theft. Sometimes that calmness unsettles a courtroom more than anger ever could.
With your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections, you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These 3 cases will run concurrently, which means together at the same time. I'm going to hand you in all 3 of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or...
This part is massive. The judge isn't just sentencing him. She's documenting future consequences. Under Texas law, once you're convicted of these felony offenses, firearm possession becomes a separate legal issue entirely. And the deadly weapon finding she mentioned earlier, that can seriously affect parole eligibility too. But then the courtroom suddenly shifts from legal procedure to personal warning. The judge brings up the bailiff's gun again, and you can hear the frustration in her voice. That means whatever happened...
or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Wilkerson. Now, let me tell you one more thing, Mr. Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if he tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now.
Phew, that wasn't a lecture. That was a reality check. The judge is basically telling him that county jail behavior won't work in state prison, especially in TDC. And whether people agree with her tone or not, One thing is clear. She believes immaturity and ego are going to destroy any chance he has at parole. A lot of viewers hear 35 years and think the sentence is the end of the story. But in reality, prison behavior after sentencing can shape everything. Housing, privileges, safety, parole opportunities, all of it. So now the real question.
But honestly, we're ready to get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave.
That right there isn't just a sentence, it's a prediction. The judge has seen enough behavior, enough patterns, to believe this isn't someone who's going to change anytime soon.
And that's what makes this case stick with people. Not just the crimes, not even the sentence. It's the prediction. The judge looked this defendant dead in the eye and basically said, I don't think you're going to change. That's heavy, because every prison story eventually comes down to one thing. Does a person stay trapped in the same mindset, or do they finally grow up before it's too late? 35 years can either bury someone or completely transform them. The scary part is nobody knows which path he'll take yet.
And when a judge says something like that in open court, it carries weight. It's not just about punishment anymore. It's about what they think your future looks like. Interview.
Prove me wrong, and that would be great. If you figure it out and start learning how to mature and act like a normal human being like the rest of us. But my money is on you not doing that. So I wish you'd prove me wrong, because everybody that has to deal with you, they're just doing their job, and you're putting them through all that. Is there a victim impact statement?
No, Judge.
Go back with the bailiff.
Thank you, Judge.
Thank you.
Excuse me.
Thank you.
So now it all comes down to, this was the judge. Right about him. Or is this one of those rare moments where someone actually turns their life around? 35 years is a long time. Sometimes it only takes one decision to change everything. What do you think? Can he prove her wrong?